Hello, everybody. Welcome to the Sunday Club. And as you can see, we have a bigger panel because we're discussing a much bigger issue today. We thought we'll focus on that. And if we have time, then we'll move into some of the hot topics of the week. But primarily, we're here to discuss the sedition law. I'm delighted to be joined by a noted lawyer, Manali Singhal, on her debut, the Sunday Club. Thank you for joining us, Manali.
Thank you for having me, Advaita.
And I might add here that your daughter is a lawyer as well, and she filed a PIL. So we're here in large degree because of her work that started this off. And of course, most recently, Justice Chandrachud has been also commenting on it, which has brought it back into focus. And of course, there's Justice Katju is joining us. Thank you, sir, for joining us again. This time I promise to be a more moderate in my tone, but I wouldn't venture too far on this subject because, like I said, my information on this and knowledge on this is limited. So I'm here really to listen more. And that's where we have Shezad Poonawalla, young lawyer, who I thought would have a very now issue and what this old law means for us today. And of course, Sunday Club regulars, Suhel, Seth, and Abhijit, and of course, Shehzad's becoming a regular as well. So, so I'm just going to throw this open and let's start
with you. Budapest.
Greetings, yes, of course. Suhel Seth is sitting in Budapest, and he wanted me to share that with everybody. And so
is that at the Grand Hotel, the Grand Budapest Hotel?
So yes, so let's start with Manali.
Yeah. Manali se Budapest. I like this picture already.
I know. The picture was good, and I have no doubt that some mystery is happening there too. So some kind of action would be happening in Budapest right now. So basically, of course, I think this whole discussion around 124A, which is the law relating to sedition, has been ongoing for a very long time. But I think it has come in the forefront in the last couple of weeks, and even I would say a year or two, more so because we see that in the recent time there has been a rampant use of this section to curb dissent and free speech. In fact, recently the Chief Justice of India also commented and said that it is a law which needs to be relooked by the Supreme Court. In fact, in my mind, in a robust democracy like ours, there is really no place for a law like this. We must encourage free speech. We must allow space for dissent. And these must not be just words. And laws like this or the use of the UAPA are actually used to have a chilling effect. And to send a message to the general citizenry that if you speak against us, if you disagree with us, then remember that we can send you in, book you under a law of sedition or under some other preventive law, and make it almost impossible for you to get bail. People, as you know, many activists, many students, many citizens have in fact languished in jail for months and years and have not been able to get bail only because such harsh and regressive laws have been added to their alleged offenses. So this has now really become a tool in the hands of the government to curb dissent and free speech, which I think the time is now absolutely right for the court, and even actually it should not even be left only to the court. It should have been the government and the parliament which should have really debate this and scrap this law completely.
All right. So Manali is all for scrapping the law. And then we go around to Shehzad to look at it from the legal perspective once more.
Well, to begin with, I have never been in the favor of throwing the baby out with the bath water. Most objections towards the sedition law is that it is being rampantly misused and that it's an archaic law. The Britishers, whose colonial legacy we carry in a large amount of our life, have done away with it. But having said that, let me address each of these issues. Now, rampant misuse of the law. Is rampant misuse of a law the only reason to do away with any law? If that were the case, then the rampant misuse of the rape law may actually become grounds for doing away with the rape law. Can we say that? Can the rampant misuse of domestic violence law be the argument being made to do away with the domestic violence law, prevention of domestic violence law? A knife is as good as the person using it. If you give the knife to a butcher, perhaps he'll use it properly, but if you give the knife to a murderer, he might kill somebody with it. So it's not the problem of the knife, it's the problem of who's using it. I'm in favor of sedition law being made in such a way, the procedural safeguards being made in such a way that its rampant misuse can be prevented to an extent that it's not applied randomly on people. As far as free speech is concerned, in our country, by the way, free speech has always been subject to reasonable restrictions, unlike America, which has absolute right of free speech. But even in America, by the way, they have a law that deals with treason, and that is far more stringent than the sedition law that we have. I believe even United Kingdom and Australia have laws that are analogous to the sedition law that we have in this country. So that is if America and other countries feel the need for that law, despite having very robust anti-terror laws, which we also have in UAPA, and some people would argue that do away with the UAPA as well. They argue that do away with sedition, and they argue do away with UAPA. Now they want to have it both ways. Now I don't understand that argument. We do require the sedition law. If it was so unwholesome, it could have been done away with much earlier, but a constitutional bench of the Supreme Court of 5 judges, if I remember correctly, in 1962 has upheld its constitutional validity. So even if we were to do away with this law legally, it will require a 7-judge bench at the very least of the Supreme Court to do away with it. But again, I stick to the argument that just because a law gets misused cannot be the reason why it should be done away with. We can put in procedural safeguards by which, and already there has been an interpretation of the various ingredients of the sedition law to an extent that merely saying statements that may seem to be, in a sense, hateful or promoting disaffection against the country alone does not attract sedition. Now, if it has been wrongly applied, that's not the problem of the law. That's the problem of the person applying the law. So I think we must be reasonable and practical. We do require the sedition law. The manner in which it has been whittled down by the 1962 judgment, the application of it, we can argue that there can be more safeguards, but to do away with it, I think would be unreasonable.
Justice Katju, do you, in fact, some people are saying that do away with the sedition law and bring a stronger law in. Can a country really exist without a sedition or a treason law? Is it possible?
No, the law is needed, but it must be carefully defined what are its limits. In USA, the famous Justice Holmes laid down the clear and present danger test, which means that if a speech results in immediate danger, then only it can be prohibited. There was that case of Gitlow versus New York. Now, Gitlow was a communist. He published an article entitled The Left-Wing Manifesto, in which he advocated the violent overthrow of the US government. Now, he was prosecuted and the matter went up to the US Supreme Court. Now, Justice Holmes held, of course, it is a dissenting judgment, that this article will not result in an immediate uprising. You know, there are so many Marxists in this country. There are Marxist professors in so many universities who call themselves Marxists. There's a CPI, CPM, and Marxism teaches violent overthrow of the state. But does it mean you can arrest all the Marxists in this country, all the CPI members, all the CPM members, all the professors who call themselves Marxists? No. If the speech or word results in immediate violence, or it results in something, supposing you tell a man, go shoot that man, you tell somebody to go shoot somebody, then that will result in some immediate violence. But if you say there should be a revolution in the country, violent revolution. Now, violent revolution can mean violent revolution after 50 years. It's not immediate. So, the clear and present danger test laid down by the US Supreme Court Judge Justice Holmes, it was further developed in a judgment called Brandenburg versus Ohio in 1969, in which the test laid down was the imminent lawless action test, which means if the speech or word results in some immediate lawless action, not in the remote, then only you can prohibit it. So sedition law can be there, but that judgment of Kedarnath Singh versus Bihar, which was still, it holds the field, 5-judge bench judgment, that also is vague and it requires to be clarified. Because in that judgment, it was said that speech can be prohibited if it has a tendency to create public disorder. Now, the word tendency is a vague word. Every criticism of the government can be alleged to have a tendency to create public disorder. So therefore there can be no criticism of the government. It can't be like that. So that judgment needs to be further clarified. It can be judged even by a smaller bench, because that 5-judge full bench of the Supreme Court has left it vague. And the Supreme Court should follow the Brandenburg versus Ohio test, that speech can be prohibited only if it results in imminent lawless action. For example, so many Kashmiris demand azadi, freedom. Khalistanis demand separate Khalistan. But that does not mean they are inciting to immediate violence or giving a speech which results in some immediate violent activity.
Okay.
So that cannot be prohibited. But unfortunately, the law, see, there are two other problems. Leave aside the law. One is cases in India take months and years to decide. So even if you are ultimately found innocent, you may be in jail for long time. That Kafil Khan was in jail for 8 months, ultimately found because he criticized the Citizenship Amendment Act. And similarly, Shajil Khan and Umar Khalid, Kanhaiya Kumar, and so many others, they criticized the Citizenship Amendment. Then that Manipur journalist, Kishore Chand Wankham, he only said that Gomut and cow dung gobar is no cure for corona. On that, he was arrested for sedition. So there's no doubt it is being, there are scores of such cases I can give you. It is being grossly misused. The person may be released after 6 months or 1 year, but will he not lose one? Because our judiciary takes years and years to decide a case. So even if you're found innocent, once you are charged, you may be languishing in jail for a long time. Then secondly, police often manufacture evidence. For example, against Safura Zargar, that pregnant Kashmiri girl who was a student of Jamia Millia. She was very active in the anti-Citizenship Amendment Act agitation. She was booked in the Delhi riots case that she was inciting the Delhi riots. To my mind, this was obviously manufactured evidence because the Delhi police is under the central government. Central government is the BJP government. The police nowadays, I'm sorry to say, they are no longer independent. Most police people have become shameless. They will, just like servants, they will obey the orders of political masters shamelessly, with abandoning their conscience. So, therefore, you cannot expect justice from the police. They will do whatever the political masters. So, Safura Zargar had to be in jail for 4 months or 5 months, although then she was only released on bail. So, false evidence is manufactured. Regarding this Bhima Koregaon accused.
Correct.
They were accused of having links with Maoists and all that. I mean, I have some grave doubts that all the evidence can be manufactured. Police in this country, I mean, don't live in some other country. Indian police, we know, most of them, I'm not saying 100%, but 90% of them have become either corrupt or dishonest. They will do all kinds of misdeeds.
Right.
They will manufacture false evidence. So that is another aspect which has to be seen. The practical aspect, leave aside the theoretical flaws in the provision for sedition and preventive detention law. The practical application also has many flaws which I have pointed out.
Okay. I'll get Abhijit in. Thank you, Justice Katju. Abhijit, you've of course also had a stint in a jail in Odisha. If you recall, I don't think Justice Katju didn't mention that one.
No, I supported him. Ask him.
He actually came out very strongly in my support when particularly Porcine CJI said that the best place for Abhijit was in jail.
Exactly. Yeah. Huh? I remember that.
That was a shameful observation of Gogoi.
Well,
Gogoi
with all due respect, what do you expect from a man like that?
And that was a shameful observation he made.
He's a shameful man prone to shameful excesses. There's nothing we can do about it. But let's focus on this particular debate. See, the previous three speakers, they've brought about some very important points. I generally oppose the sedition law, but I'm going to tell you why there is serious problems in getting rid of it. Right. Number one, we need to understand what is the developmental difference between India and the UK. See, you can say the UK has gotten rid of it or America has gotten rid of it, but America and UK are developed first world societies. In the UK, the state has complete monopoly over violence, right? So the conditions there, the anthropological conditions there are very, very different from India, number one. Number two, this is a point for the sedition law. The point against the sedition law is that because it came from a colonial mindset, the fundamental basis of it was to minimize the cost of the occupation. So the state does not absorb the cost of maintaining the peace and protecting the individual rights, the right to freedom of expression. What it does is it passes on the cost to the individual citizen. Your freedom of speech is guaranteed as long as it doesn't interfere with our profits in extortion from this particular country, right? So this is one of the things against it. The third problem, which has now complicated our jurisprudence, is that you have a severe intermingling of the Anglo-Saxon code and the Napoleonic code. Okay, on one where there is a presumption of innocence and one there is a presumption of guilt. But remember, with the Napoleonic code, it was brought about when you have extraordinary police reforms where an investigation carried out is to an extraordinarily high degree of investigation, and the probability of conviction is also therefore high, right? So unfortunately, in Indian law, you have two completely different streams. On one hand, you are happy to proclaim innocence of one, but in certain other cases, especially women-related cases, the presumption of guilt is automatic. You then have to prove yourself innocent, right? Which is highly problematic. So it's perfectly fine getting rid of the sedition law as long as you combine it with good policing, which comes in because societal violence is so high. Till then, you have to give the state some kind of arbitrary powers to use when it sees situations go out of hand. Mm-hmm. Now, the point that Manali raised, which is of the chronic abuse of the law, is extremely important. So all the solutions I've given you up to now are long-term solutions, police reforms, etc., etc., etc. The problem here is judicial capriciousness. Okay, this is the short-term solution, because you can't have different judges. Jurisprudential standards are a joke. You can go to one judge and get a different judgment, another judge, a different judgment. Depending on what previous judgment you cite, it's about, when you do risk consultancy for companies coming into India, the single biggest component of it is judicial capriciousness, judicial unpredictability and regulatory unpredictability. So this is a very serious problem, which is, and I would say that is at the root of the abuse of the law. Because remember, the state and the judiciary exist in a negotiating position where one always tries to, go over the line, and it is for the judiciary to control it and push it back. The problem in India is sometimes the judiciary just gives in and allows the state to trample all over the citizens' rights. Okay. Now, Justice Katju would never do that, but there are several justices who would do that. The porcine character we referred to earlier specifically. So there is a particular issue out here, which is you first need to get the jurisprudence in order. And what I would suggest is, because laws and their intent are a legislative prerogative, it is time for the legislator to pass something like a sense of the house or whatever to say that, this is how we interpret the law and this is how you will interpret it. Because remember, it is the legislature that represents the will of the people. So I don't think you need something as serious as a amendment, but you certainly need to bring in these. And remember, all these checks and balances went out with the basic structure argument. Because at that point on, the judiciary has become this sort of self-regulating, closed echo chamber thing, which violates virtually every other basic principle of the Constitution. Okay, in terms of checks and balances. So I would say that the 99% of the blame of the abuse of the law, which is a chronic problem, lies with judicial capriciousness.
All right. Forcefully made. And finally to Suhel for his opening comments. Suhel, are you feeling more free in Budapest?
It's not about freedom. And as Justice Katju advised you the last time, you should take a more neutral stand while moderating the Sunday club, rather than be, pernicious about people like us.
Yes.
So I have 4 or 5 things to say. Number one, sedition's definition is conduct or speech meant to incite against the authority of the state or the monarch. Monarch we don't have, in a manner of speaking, but the state's authority is there. Number 2, any law can be used to fuel and to satisfy a pernicious or an agenda-driven cause. But there's a larger issue here. The issue is of perception. You cannot have a democracy which is partial, just like you can't have partial pregnancy. The laws in our country and the way they are adjudicated upon is the issue. The issue is also of basic training and basic awareness amongst people who are the law enforcers on the ground. As Justice Katju said, a lot of the people who are the first line of enforcement are willing to placate, please, or pander to the wishes of their political masters. So why would you blame the law? You also need to blame those politicians or political parties, and everyone is involved. So please don't think this is a BJP issue. This sedition law was untouched by all those so-called legal luminaries who were earlier part of the Congress regime, and before that in Vajpayee's regime, and before that with Chandrasekhar and all those. So liberals have caused more damage to actually the definition of India than most people, because that liberalism also is agenda-driven. What Shreya Singhal, Manali's daughter, said in her PIL was actually the essence, that a democracy must take a stance on not only the effectiveness of sedition in a democracy, but the manner in which it is enforced and the punishment that is meted out to people who are convicted of that. I have therefore the following solutions. I'm not going into the problems, we all know the problems. Number one, I don't think we should do away with the law of sedition, because we are in a fragile situation and have been for years. There is rampant communalism. There are people, and Justice Katju himself said, there are people seeking independence from the state, breaking away, some of it very serious. Look at the plight of the Kashmiri Pandits who had to flee. No one talks about that. Look at the plight of ghettoization when they wanted to return. There are some serious communal powder kegs that are available in our country to be incited or stoked. I have the following solutions. Number one, like you do for evidence gathering, there must be a magisterial approval before the law of sedition can be chapoed on you, before you can be taken in for under the law of sedition. Number two, we should have, like we had in the good old days of Tada, you should have fast track courts which try laws of sedition. Number three, the Supreme Court must, through its general influence, create a parallel judicial track, which is very simplistic but very clear in terms of what attracts sedition and what doesn't. Number four, the penalties, both fiscal and punishable through prison, need to be also defined. Number five, if the law is abused or used for political vendetta or for any other kind of vendetta, there must be demonstrable punishment on the person who's using that law. See, then people will stop. For instance, let's say if it's a politician who is a serving legislator or serving member of parliament, and he's the one who's filed the complaint. Take away his, MPship or MLAship. People get worried when their power or their money is seized. They don't care about anything else. And finally, my solution, exactly what Shehzad alluded to earlier, is don't throw the baby out with the bathwater. Abhijit mentioned how and what level of dangers we have, in front of us as a country. There must have been a reason which was different then, but that reason has not completely evaporated. We need legal luminaries, we need experts, jurists to come together and to decide, now that we are a democracy which has tested waters for a long, long time, what is it that we need to do under this particular law, which prevents three things from happening. One, which stems communalism of any sort, whether it's called to arms, whether it's inciting one community against the other. Number two, where it threatens to break the state because of reasons other than dissent. See, a lot of people make the mistake saying, oh, but can't I have an opinion against the government? Of course you can. You can even abuse your own country. No one is saying that. People have been abusing, whether they are in power or out of power. But it is the tonality, it is the mechanism, and it is the way that you incite the people of India. Finally, there must be controls in terms of amplification of such messages. We keep abusing the Twitters and social platforms, but there's a lot of media that loves to sensationalize any of these messages. And they have nothing to do. I mean, they just get away scot-free, but they are the amplifiers. They are the ones who are taking the message of hate, the message of divisiveness, and the message of despair to the last person standing. And they just get away. So I'm not saying don't have the law, but certainly A, don't have the law in its present shape. B, when you do have a law which is more robust, fair, equitable, and demonstrably equal, then have a jurisprudence system which governs it and which dispenses justice with immediacy, not justice which takes 20, 30 years.
Right.
Thank you.
Thank you, Suhel. And I think Manali wants to come in also. Just a quick question, also about your speech and consequence, like where, Justice Katju mentioned some names involved with the CA protests, which then eventually, led us to the violence that we saw in February of 2020. So if the consequences end up being violent, even if at the time of protest, that is not what you're saying, then what happens? It doesn't take 50 years for violence to take. It can happen in a few days or in a few hours or next week. So I think that gets complicated as well, doesn't it? Manali?
Oh, you're asking me. I'm so sorry. No, so I want to just, yes, it may get complicated, but I want you, for example, let us take a very recent case of Natasha Narwal. It was a young girl who was arrested in the anti-CA protests and all. And she recently got bail from the Delhi High Court. And hers and a couple of other people who were arrested with her, they were charged both under UAPA and sedition law under 124A. Now, the whole idea of imposing these, and especially 124A or UAPA, is to show to a court so that when the matter comes up before a magistrate, he's like overwhelmed because here is, a trumped up charge, completely disproportionate to actually what may have happened, and to say that these are people who have incited violence and all. The facts are absolutely different. In fact, the court has found there was nothing, no evidence to link anything what these people did or said to the violence that occurred thereafter. But they languished in jail for months, and I think almost a year, if I'm not wrong. And this young girl, one of them, lost her father, got only interim bail for, could not take care of her father when he was ill. I mean, it was, according to me, there was a complete systemic failure. Look at Father Stan Swami's case, for example. Again, they were, what are we doing here? What are these laws being used for? And this comparison which Shezad made, for example, rape laws are misused, or this, that way every law is misused. Why have laws at all? Because when there is something, there will be a tendency to misuse it. We all know it. It happens all the time. Every law will be misused by somebody or the other. But should you have a law in existence which is now 99.9% used only to curb dissent and free speech? And just see how vague this law is. I agree with Suhel, some of Suhel's suggestions. But if you want to have a law, for example, for communal harmony and all, disharmony and all, there are already laws. How many laws do you need? Do you need laws only which can be, I think there has to be clarity. We need to be sure, and laws which have been done away with the countries who themselves had drafted these laws. These were laws for offenses against the crown, disharmony or whatever against the imperial powers.
No.
You had people like Tilak and all who were charged under this sedition. Should we, after 74 years of independence, in a vibrant, and I would say one thing, that we may not be a very developed country, and yes, we have a lot of problems now, and I agree with Suhel that we are seeing and we are going through some of the most difficult and precarious times, and we have to watch how our country shapes from here, because this could otherwise be disastrous for us. But I honestly don't believe that having a law like this helps. I think, yes, I'm not saying that you should not have a law if there is someone who does some serious, anti-national activity or causes something which will cause some grave danger or damage to the country. There should be no law for that. But I think 124A as it stands does not have a place today in India. If you see all the cases that it has been used in the recent past, and as Suhel rightly said, that yes, there has been a rampant use since 2014. The statistics show that the law has been misused, I would say, much more. But it's not as if every single government, every single party is guilty of having misused it. When you have powers like this, there is a tendency, because that is your only way for a person. And where I say that this has a chilling effect is, take an example. We can be quite a ridiculous country. So, Section 66A had been scrapped of the IT Act, which my daughter Shreya had challenged, and it was scrapped by the Supreme Court in 2015. Recently, Justice Nariman had to, in fact, clarify and pass orders again, because this law, which had been completely scrapped, was still being used. People were being charged under 66A of the IT Act. Some 250 people were charged with this, despite the fact. Even courts in Delhi, I can understand somewhere, some remote court somewhere, someone doesn't know, though that is not a defense for either the court or the police. It is happening. We know how the system works.
Sure.
And so I really feel that, given what we are seeing and the way things have, happened, we certainly don't need a law like this, which we have to have clarity. We cannot have laws which are vague. We cannot have laws which can be interpreted to the convenience of certain people. We must,
Can I come in now?
especially when they are punitive in nature, the law must be crystal clear. As Justice Katju also rightly said, okay, I agree with this, that yes, you must define exactly
Can we have a dialogue rather than a monologue?
Okay.
Yeah. So Advaita, because I was resisting actually to make this a pre-2014 and post-2014 dialogue, but now that it has been done, let me put some facts before all the panelists and those who are watching. By the way, we are in this situation simply because in 1951, the courts had actually done away with this law, but Jawaharlal Nehru had put in the reasonable restrictions to Article 19, the freedom of speech. And therefore, after that, this particular law survived. And in fact, let me tell you that it was made a cognizable offense for the first time, thanks to Indira Gandhi's government. Now, let us also understand that pre-2014, this law was used against Asim Trivedi, it was used against the Kudankulam protesters, and it was used as widely as it is being used today or misused today. And in that time also, the 2011 judgment, by the way, of the Supreme Court has clearly defined when this law can be applied. In fact, 1995 judgment also, if you see, of the Supreme Court in Balwant Singh case, mere sloganeering or demanding even a separate Sikh state did not apply or invoke sedition. It was to be followed up with imminent lawless action. It has been clearly defined by the 2011 judgments of the Supreme Court. So there are two ingredients. One, there must be speech which is hateful or is invoking disaffection against the country, but it must also be one that leads to violence or is violent and it incites violence immediately. This has been defined by the Supreme Court. So when we sit here, we must give the clear picture that the Supreme Court has defined what sedition means and how it is to be applied. Now, if it is not being applied by certain people in certain state governments, and thanks to Mrs. Indira Gandhi, because of whom now this can be used as a cognizable offense and police can apply it without and can arrest people, that is, the credit should be given where it deserves to be given. Mr. Nehru considered it, and he was obviously, along with Mahatma Gandhi, he fought for independence of this country. He called it an obnoxious law, but his generations and generations after that did not feel the need to actually walk the talk on what Mr. Nehru said and to do away with the law. The ones who had brought Section 66A, the ones who actually made sedition cognizable offense, the ones who have applied it liberally against Kudankulam protesters, today come here and sit and they say that, look, sedition is being used to stifle dissent in this country. It is as laughable as when they labeled a bunch of people as urban Naxals in the 2013 affidavit of the Ministry of Home Affairs and said that Maoism is the #1 threat to this country. And today they come and eulogize a man who rightly deserved to languish in jail, Stan Swamy, who, by the way, a court of law has said that he was a member of a banned group. The court of law said that he wanted to overthrow the democratic state. A court of law said that he received money for doing so. And if he died in a hospital of his choice, by the way, he was in Taloja prison, which comes under the Maharashtra government, which is run by the Congress party. Then we must ask questions as to what the Maharashtra government was doing, because the NHRC had taken cognizance of his situation and had told the Maharashtra government very clearly that he should be given all the facilities. And he was given every facility, including a sipper and a straw, that the liberals are very worked up about.
One second now. Now let's also have a dialogue now.
Absolutely,
let's not have a monologue now.
Because you went on and on.
No, I'm sorry. A first clarification.
Manali ji, you went on and on.
One minute.
You should have the patience. Tolerance is a two-way street.
One clarification.
Manali, tolerance is a two-way street. And clearly you don't have the habit of walking on it.
Unlike
tolerance is a two-way street, and you should also start walking on that path. Now listen, let me complete. You spoke for 7 to 8 minutes. I have not spoken for half the time, but truth is an inconvenient pill. I understand that.
Unlike you,
Manali,
I'm
truth
not
is very
attached to a
inconvenient.
political party.
I
And
understand.
I, in fact,
You don't need to be
I
from a
made the
political
point
party. You're still a political
that
person. I mean,
every political party has misused
unless you
this
think
law.
only people who belong to a
I
political
said
party
it
are
very
political.
clearly, but you probably did not
Look, now this is the
listen
problem.
carefully.
Advaita, I did not interrupt when she went on for 10 minutes.
Manali,
Now, clearly, she can't handle the truth, which I understand she can't, but that is all right.
nothing personal. Let's just
No, there's nothing personal, but the facts must be kept as they are.
please
So
go ahead.
so let me complete. And after that, Manali is at liberty to defend whoever she
No,
wants to
may I
defend
interrupt?
in this
May I
discussion.
interrupt?
Before I was interrupted, I was only saying that we must realize and remember that we are here because of certain people who come here and preach from the pulpit of morality, did exactly reverse of what they come and preach here today. They come and eulogize people like Stan Swami, against whom there are observations and strictures of a court. They come and eulogize even people who've been convicted by a court. They go and stand in defense of those who've stood in who have actually raised slogans in favor of Mr. Afzal Guru and in favor of Yaqub Memon, saying कि वो हालात का मारा है and Afzal Guru was executed because of a judicial hanging was done. So I don't need certificates from these people. Let's acknowledge for these people are the past masters of hypocrisy and doublespeak. They did something else while they were in power. They called them urban Naxals. They put all these likes of Gautam Navlakha and others in jail. They said it was national security then. Today they come and say it's dissent. And they do the same thing with 66A. They come and do the same thing with the sedition law. They used it liberally back then. Today the law has many safeguards. If at all, if it's being misused, the law is proper. But those who misused it should be punished. The Supreme Court should come up with more detailed
Exactly
guidelines.
what I said.
And by the way, I need no certificates from anybody about my behavior. Those who have lived a life of getting benefits from A and B should not be the ones preaching to me about whether I'm a Dal Badlu or not. And I think it's clear about who got what benefits from which government.
Okay, now let Justice Katju, 1 minute. Advaita, I'm moderating it for the next 5 minutes to bring peace. Justice Katju, Manali, Abhijit, me, all of us, and Shehzad, of course, we raised certain issues about the use and abuse of the law and the role that the judiciary can play in terms of making it more somber, more robust, and more equitable. What are your views, sir?
My view is that in practice, no government will do it because this sedition law is a handle whether to Congress government, whether to BJP government. It is a handle for them to suppress dissent. So no government will initiate any proposal to change the law because the government is happy with it. They can use it to suppress opposition. And so far as police is concerned, they will obey orders of the political masters. Unfortunately, it has come down to this. This is the truth. You know the realities in India. So I am very pessimistic. I don't think there will be any improvement.
No, but as a former Supreme Court judge, if I were to ask you, or we were to ask you, that when you were, or if you look at it from the pulpit of judicial intervention, apart from the pessimism, what solutions do you see other than completely scrapping the law? Because the problems are not getting scrapped. The law may get scrapped, but even Manali agreed that the problems are simmering and they are underlying.
As I said, that Supreme Court should now give a very strong judgment upholding the unlawful activity test laid down in Brandenburg versus Ohio. But even if Supreme Court does it, the problem is this: even if Supreme Court does that, uphold that unlawful activity test, there are two practical difficulties. That once the police charge sheet somebody, it will take years and years to decide the case. So he will languish in jail till then, and very often bail will not be granted. So even if you change the law, but in practice, because the courts take years and years to decide a case, so the man will remain in jail. Like, for example, take the case of these Kashmiri leaders who were arrested on 5th August 2019. Farooq Abdullah, Omar Abdullah, Mehbooba Mufti. Now, soon thereafter, habeas corpus petitions were filed in the Supreme Court. They were adjourned again and again and again. And in the meantime, those people were languishing in jail. Ultimately, it was the government who released them, not the court. And I think some people are still languishing in jail. So from the practical point of view, the courts keep on adjourning cases, so the case is not decided. Even if ultimately there are cases where a man was acquitted after 23 years serving in jail, Nasir Khan or something like that. And there was one Amir, he was in jail for 14 years, then he was released. There are so many cases. Here they are kept, ultimately they are found innocent, but they spend 14 years, 15 years in jail. Then second practical problem is that police often manufacture evidence. This is the reality. I know I was deep in the system for 40 years, 20 years as a lawyer and 20 years as a judge. I know police often manufactures false evidence. Possibly in this Bhima Koregaon case, where these people, Varavar Rao and Sudha Bharadwaj and Gautam Navlakha and all, they are still in jail. And it, quite possible that police manufactured evidence against them, or that Professor Sai Baba. So in this case of this Safura Zargar, he was accused of inciting the Delhi riots. I mean, she's a student in jail because she participated in the anti-CAA protest. So she has been charge sheeted for inciting the Delhi riots. Then Disha Ravi, that environmentalist, was accused after a long period. She was released. Siddiqui Kappan, Asim Trivedi, that cartoonist, was arrested because he took out cartoons against the politician. Professor Ambikesh Mahapatra was a professor in Jadavpur University, one of the best universities in India. He drew cartoons of Mamata Banerjee and he was arrested.
But that's exactly, sir, if I may come in.
Point, yeah. Abhijit wants to.
That's exactly my point.
Give Suhel.
Let Abhijit come in.
Yeah, Abhijit, just come in.
And now you take over back.
Okay. So I just wanted to say very quickly, see, I don't have an issue if you get convicted under the sedition law. My issue is incessant holding under the sedition law, where the process is the punishment. Okay, if you're found guilty, डालो जेल में, भाड़ में जाए. ठीक है? But bail has to be very clear that unless there is a danger of you doing a crime when you are out, see, the bail conditions have to be different. A, is there a fear of this person running away or absconding or whatever? B, is there a condition that this person will, communicate with his collaborators or whatever? And even if there is, you can do basic things like house arrest to minimize his communication with the outside world. Okay, if you say that is too much, police infrastructure used for something like that, you still can't deprive a person of their liberty unless they are found guilty and present a clear threat to society. Okay, agar he is found guilty, send him to the Andaman and Nicobar Islands. Send him to be the next meal of the Sentinelese or whatever it is. But till then, you can't just keep people in jail for so long. It's obscene. It's uncivilized. And mind you, when Colonel Purohit and Sadhvi Pragya, they were originally charged. The charge sheet was done within the stipulated period. But that original MCOCA was dropped after 3 years, and for 3 years they were kept on jail on charges that were then dropped.
Yes.
This entire thing is a joke. And the problem here is I'm afraid that in both the sides are making very good arguments. Manali makes very good arguments. Shehzad makes very good arguments. The problem is it is the ordinary man that gets screwed over because either government, it doesn't matter, Congress, BJP, they're hell-bent on screwing us all over. तो अब क्या जाए इसका? So I'm very happy to admit that P. Chidambaram misused the law terribly. What, 9,000 cases registered in one day against the Kudankulam protesters.
Yeah.
पर भाई उससे मेरा क्या relief मिलने वाला है उसको? if somebody drags me off on sedition, what solace is it to me that P. Chidambaram did it or Amit Shah did it? I'm still going to spend 8 months in jail, na?
Yeah. Yeah.
So, and I just want to say this for what it's worth. I've seen whatever the cases are against Natasha Narwal, Umar Khalid, and all of that. It's all he said, she said. I've not seen evidence yet. At some point, the judiciary has to take responsibility for this, because the role of the judiciary is that when the state exceeds its limits, it is the role of the judiciary to protect the citizen against the state. Sadly, the judiciary in this country is completely complicit with the persecution of citizens along with the state, till or when they find the government is on a political down spiral, in which case, we remember the shameful record of the Supreme Court when it came to the emergency.
Yeah,
okay, in virtually, देखो जब कोई consequences नहीं है ना, तब grandstand करना Supreme Court को बहुत आसानी से आता है. When the stakes are high, they have thrown us under the truck every single time. So let's not make this a political debate, because there is an institutional rot that is set in out here, which also needs to be discussed. Thank you.
Thank you so much. We've got about 2 minutes left till we hit 8, but Manali wants to come in, Justice Katju wants to come in, Suhel wants to come in, and I'm sure...
I've hardly spoken.
So, so we'll go with, as the fingers were raised. Oh, Justice Katju's... What happened? Oh.
Continue.
Justice, so you wanted to come in when Abhijit was speaking? Oh, he's got his notes out. Okay. Right, Justice, we're listening.
Yes. See, I want to say that in theory, what Abhijit and Suhel have said is all very good. Abhijit has said police should be reformed and judiciary should be reformed. It won't happen, Abhijit. Let me tell you, my grandfather was Chief Minister of Madhya Pradesh, 57 to 62. At that time, there was a very upright Inspector General of Police. In those days, there were no Director General. The highest rank was Inspector General. He was K.F. Rustamji, a Parsi gentleman, very well with very high integrity. K.F. Rustamji. He was Inspector General of Police. Now, my grandfather, Dr. K.N. Katju, was Chief Minister, and he got a complaint against some police officer, and he was going to suspend him. Then Mr. Rustamji came to my grandfather, the Chief Minister, Dr. Katju, and said, "Sir, please don't do this. It will create a lot of demoralization in the police force. Allow me to handle it. I am the head of the police." So Dr. Katju said, "Okay, that's fine." And Mr. Rustamji handled it in an appropriate manner. I don't remember exactly what he did. But this was the respect which the politicians had for the bureaucracy and the institutions. I'll give you another example. My grandfather was Chief Minister of Madhya Pradesh, and the Chief Justice was Chief Justice Hidayatullah, who later became Chief Justice of India.
Mohammad Hidayatullah.
Mohammad Hidayat. So when the Chief Justice recommends names for elevation as High Court judges, and when the list first comes to the Chief Minister, thereafter it goes to Delhi. So my grandfather, Dr. Katju, told the Chief Minister, told the Chief Justice that, "Look, Chief Justice, this is your court. Whichever name you recommend is acceptable to me. Except if I get some complaint against some recommendee, I will forward the complaint to you. You look into it. If you still think that after looking into it that he deserves to be a High Court judge, I have no problem." So this is the way how a system functions, by the politicians respecting the institutions. Now, Abhijit has said reform judiciary, reform police. It won't be done, Abhijit. These people have no respect either for judiciary or for police. Police, they treat us as servants. These police people will do anything to keep on the good side of the government. Those days are gone when a person like Mr. Rustamji would not put up with even the Chief Minister. Those days are not here. So don't live in a dream world. It will not change. See, I'm a pessimist. I'm sorry to say. You can keep holding these webinars. Nothing will happen. It will continue as it is. Chief Justice of India, no doubt, has given recently a statement about this in a petition by an army veteran. He said that about this, he spoke against the sedition law. But these are only oral observations. A judge can make any oral observation. The point is, what is the verdict which you actually deliver? That is what matters. Oral observation can be anything. In fact, Ramanna has been giving a lot of speeches nowadays, saying all kinds of things. But it's not your words which matter, it's your deeds. Let us see what verdicts he delivers. This is relevant, not his. People are jumping. I saw on internet, people are jumping with joy that, oh, great observation. They mean nothing, oral observation. The verdict may be entirely different.
Right.
So this is all I want to say. I'm a bit of a pessimist. Thank you.
Thank you, Justice Katju. And Manali, over to you.
Yeah. So I don't want to get into another squabble here and dignify the outburst of Shehzad.
Manali, could you speak up, please? Can't hear you.
Can you hear me now?
Speak up.
Can you hear me now?
Yes.
Yeah. I said I don't want to dignify Shehzad's outburst, but I do want to clarify one thing. First of all, he butted in when I was speaking by saying this is not a monologue but a dialogue. So just to clarify that, I don't think maybe I spoke longer than I should have, but maybe then Advaita, you should have told me, Manali, let somebody else speak.
Right.
But he did definitely butt in and say that. Secondly, I don't hold a brief for any party. In fact, even when he talked about 66A and things like that, 66A was a law which had been introduced by the UPA. My daughter challenged that law, and we have no political agenda whatsoever, unlike some other panelists over here. So there is no offense if you talk about Congress, Nehru, Gandhi, Modi, this thing. I am happy to call a spade when something is wrong, okay? And we are here as citizens of this country and as people who should debate these kind of issues because it's important to debate them. And we are not here holding, I didn't know that I was coming to a political panel where I may be, just because I said that the statistics which I referred to of 2014, these are not my statistics. These are now published statistics in the public domain, which shows the number of cases that have come in and how they are being handled. And yes, it's very well to say that the Supreme Court will let this one off and let that one off. Like Justice Katju said, for the Supreme Court to let out, imagine how many years or months it may take for a case to come to the Supreme Court. What happens to the person over there? And yes, Father Stan Swami did finally get a straw because he could not even eat and his hands were shaking so much. But the fact of the matter is the government opposed him from getting a straw in court. The fact of the matter is that the prosecution opposed a basic human right to a person like this. What happens when you have laws like this? The very reason to apply these laws and to put this section in against anyone is to magnify the case so much that a magistrate will say, oh, sedition, UAPA, maybe it's a very, very grievous offense. Maybe I should not give him. There is no evidence. Everything is just prima facie at that stage. You get like Dr. Katju, Justice Katju said, you get a trumped up FIR, which will say this was done, that was done. In how many cases is there conviction? Let's look at all that. The fact of the matter is these laws are not used for conviction. These laws are used to curb dissent. These laws are used to curb free speech. Let's make no mistake on this.
Okay, Manali.
Can I have?
Yeah, this is today to like what the.
This is like a fiery Sunday.
No, I hope you will give me my opportunity to respond.
You
But I
finish,
leave it to
Shehzad,
you.
you finish first. You finish.
You go ahead, Shehzad. Go ahead.
First of all, I don't seek my arguments to be dignified or validated by anybody who I think is a partisan peddler of facts. Firstly. Secondly, the act of being political doesn't stem from just having an affiliation from a party or from getting benefits of it, whether it's covertly or overtly, or whether it is about somebody's family being in that party, but it comes from the act that you actually sit here and do not state the full facts because you have a political agenda that you want to drive at. And I'm very happy with those who are now very, very vocal about the deprivation of a straw to a person who was considered a Maoist by the courts. And all these arguments were before the courts. But I'm also very eager to know where were all these activists and all these champions of human rights when Sadhvi Pragya, who's not been convicted by any court of law, or Colonel Purohit were being deprived of their basic human rights. And at that time, I saw no champions of these liberal values come out and say that this should not be done. So, it's easy to come here, lecture everybody, preach from the moral high ground. This is, and I didn't know, Advaita, this was going to end up being one of those sessions where I had to take moral science lectures from have-beens. But having said that, let me just tell you finally that the process may be very tortuous and arduous, and therefore the process needs to be rectified. And I think that it's high time judiciary owns up to what it has done in this country. For instance, this same judiciary where one of the panelists has served took suo moto cognizance against the Kavad Yatra. The Kavad Yatra has been stalled, and you have Eid celebrations going on in Kerala, and the Supreme Court is not saying anything. So I think that high time we start putting the blame where it should be put, that is namely at the doorstep of the judiciary for not doing its bit, rather than coming and blaming only the executive. And even if you have to blame the executive, be fair in doing so. Otherwise, be happy to accept that you are as political and as partisan than you accuse of the other person of being.
I mean, I met Colonel Purohit briefly in Pune, and he went through a really traumatic time. There's no doubt about that. And it went on for years. Suhel, yes, please.
I've heard every panelist, but I've also been utterly saddened today. And this is serious. I'm not being jocular or... What has saddened me are the observations by Justice Katju saying that nothing will happen in India. What saddens me further is not that he's 75, but that he served on the highest court of our land. For a man who was part of the judiciary, whose only job is to retain, honor, enforce the sanctity of the Indian Constitution, for him to now say that we can't have police or judicial reforms is, to my mind, a terrible indictment, not only of our country, but of themselves, of himself, of the judiciary that he served on. But I'm not a pessimist. I genuinely believe that discussions like this, if they don't blow over, are important to have in this country. See, you can always disagree, but you don't have to be disagreeable. You can always have a point of view, but that point of view is not sacrosanct because there are facts. Yes, Prime Minister Modi's arrival 2014, there is statistical data, but there is also the fact that Jawaharlal Nehru got a poet like Sahid Ludhianvi banned because of the lyrics in Pyasa. So this is not the forum for this versus that. And I don't think either Manali or Shehzad or Abhijit or even Justice Katju were looking at that. My feeling is that if we don't repair the wrongs that we have allowed to be inflicted on us as a polity, as a people today, we will never be forgiven by future generations of Indians. Democracy is not about once in a 5-year period to going out and voting. Democracy is ultimately about dignity. Dignity is about respect. Respect is about freedom. Freedom is about accepting contrarian views, but adhering to one uniform law, whatever that law may be. If we have to reform the police, it needs to be done. If we need to undertake a massive cleansing of the judicial process, it needs to be done. I'm telling you things that are wrong. Why should we attract the best people to the bench when people at the bar are earning more in 5 minutes than people at the bench make in a lifetime of service while they're tenured? Why? When the stakes are so high, why should a politician be put on the mat when he or she every 5 years has to go out and seek a vote? Whereas the bureaucracy, which is primarily the policy implementing and making arm, sits without any accountability. So, Advaita, we can keep having these discussions, and I'm a great optimist. I genuinely believe we are a great country.
Right.
Not because we are India or we are democracy, because we have a civilizational legacy. We have a legacy of harmony. There are people who have created disharmony and who have continued to create disharmony from time immemorial. But India and the idea of India survived that. I'm saying don't go down the path of pessimism. Pessimism, sir, it's fine. I completely understand where you come from. But I'm saying that it's not a good thought to share with young people, young Indians who are watching this program to say that nothing will happen. Kuch nahi hoga. Desh khatam ho gaya. But we were all part of that process. You were as much a part of the process of finishing the country as perhaps me or anyone else. So my appeal would be that to look forward, we have to look back. To look ahead, we need to know the wrongs that we have committed. And there is no wrong in the world that can't be made right.
Yeah. Yeah. And I just don't, I think that it shouldn't be so easy to put people in jail and let them languish there. And Justice Katju and then Manali after that. We're going over time now, but everyone's still engaged, so.
Suhel has said we should not be pessimists. Let me say our political system largely, not 100%, but 90% runs on the basis of caste and religion. Shezad accused me of saying that 90% Indians are idiots. I said, yes, because when 90% Indians, when they go to vote, they don't see the merit of the candidate, whether he's a good man, bad man, educated, illiterate, criminal, nothing. They just see his caste and religion, or the caste and religion which his party represents. That is why maybe you have half the members of parliament have criminal background and a large number of state legislatures. When 90% people vote on the basis of caste and religion, are you not a bunch of idiots? Don't keep talking of democracy in the air, Suhel. This is your democracy. People.
It is not my democracy. It is our democracy.
Our democracy. धीरे भाई साहब धीरे सीधे जात बिरादरी पे डाल देते हैं वोट. ये तो रियलिटी है इंडिया की. अरे आप बातें बहुत कर रहे हैं. देखिए रियलिटीज पे आइए. Come to, don't talk of abstract theory.
I agree.
The ground reality is 90% Indians when they go to vote सीधे जात बिरादरी भाई साहब दे देंगे. 90%. I'm not saying 100%. Or 90% is what matters. That is why you have so many criminals with people with criminal.
So when you were a judge,
that is why I am such a. See why I'm a pessimist. It's not that I want to be a pessimist. I would be happy if my country is progressing. But you have the parliamentary system of democracy in this country, and parliamentary system of democracy further entrenches casteism and communalism because it runs on this basis. The politicians polarize society, नफरत फैलाते हैं. आपके नेता लोग सब पार्टी के. I'm not blaming BJP.
But here is the irony. You're abusing the same system. You're abusing the same system that you were part of. You're abusing the same system.
Am I denying that I was part of it?
No, you're not denying that, but you're denying the fact that you're abusing that system now that you're out of the system.
No, I was not in politics.
Once you get out of the system, then you start abusing everything.
Suhel, I was not in politics. I am saying the political, जो हमारी parliamentary system of democracy है, it runs on the basis of caste and religion. 90%. भाई साहब सीधे जात बिरादरी पे आंख बंद करके वोट डाल. तभी ज़्यादा. I never go to vote. I'm 75 years of age. I have never voted. I will not vote. Why should I vote? Why should I behave like a fool when my vote means nothing? 2 लाख यादव वोट पड़ गए, 2 लाख हरिजन वोट पड़ गए, 2 लाख मुस्लिम वोट पड़ गए. तो मेरा एक टू वोट का क्या मतलब है? इट मींस नथिंग. 2 लाख मुस्लिम वोट पड़ गए, 2 लाख यादव पड़ गए, 2 लाख कुर्मी पड़ गए. भैया मैं घर बैठा हूँ, थैंक यू वेरी मच. आप लोग डालिए वोट भेड़ बकरी जैसे, मुझसे नहीं हो पाएगा. तो 90% इडियट. मैंने कौन सी गलत बात कही? सही, बिल्कुल सही कही मैंने. I'm not saying 100%.
But my question is, are you part of the 90% or you're not part of that 90%?
I'm part of the 90%.
ठीक है, that is fine.
Advaita, ironically, those who preach the Constitution day in and day out are disrespecting the first 3 words of the Constitution, we the people, on a daily basis. And then they come here, they lecture us on and on. The one important thing that has kept democracy in this country alive are the people of India, and they are being called as fools and whatnot.
Everyone can have their views. Now everything don't
We
be.
should.
Anyway,
and yet they won't be charged with
anger and
sedition, by
negative
the way.
energy. We should all meditate.
Let's
I mean, you will be called a communal person. Abhijit, you're saying Om. You'll be called communal.
hello.
Be careful.
Manali.
I thought I was supposed to go next after Justice Katju, but anyway, well, my point is, I think I really think that Suhel said something very pertinent and something very positive, and I do agree that while we all feel today the pressure and the frustration of the system. I want to end this because he says, what is the message that we are going to send to the young viewers, to the young people of India today? And I'm telling you this because this is a first-hand experience that I have had. My daughter was all of 21 years old when she filed a petition in the Supreme Court of India. And she managed to see that a law which was regressive, which was very, misused rampantly, was struck down.
Right.
So yes, I want to, like Suhel said, on a very, very positive note, yes, we must all debate. We must talk about this. These are not partisan issues because every party is guilty of having misused this. And they will continue to do it. It is our moral, legal, constitutional duty to raise these issues, speak about them. And for the young people of India, please take them up in court. Take them up, yes, absolutely, Abhijit. Take them up everywhere, wherever you can. If you want to protest against CAA, you want to protest against anything, please do it. That is your fundamental right. Do it peacefully, and do it, there are restrictions to free speech, but within those bounds, you can do everything. And please do it. Exercise this right of yours freely. It's when we show and we do not stop exercising this right, whichever government may be in power, they will have to listen to us ultimately. And thank you, Suhel, for that very, very positive note that you said.
Thank you.
Can I just have one line, Advaita?
I'm having fun. I just wanted to say that. I'm hoping that after COVID, we can all be in a round table and there can be
Abhijit, ironically, just to tell you, and this is where I agree with Katju ji, the CAA protesters, even while the law was challenged in Supreme Court, sat on my roads, blocked my fundamental rights for over 100 days. Yes. And I'm glad that Mr. Katju and I were on the same page as far as that was concerned. The illegal protests of Shaheen Bagh and all those youngsters sitting in illegal protests of Shaheen Bagh should take the cue from here and go to Supreme Court rather than block our roads. And one-eyed liberalism and one-eyed secularism in this country should also end.
Absolutely, Shehzad. So I wrote that in my piece in News 18 saying that, this kind of non-application of law, people squatting and inconveniencing the public. Yes. The Supreme Court can't take 1 or 2 months to hear this. I've seen this nasty habit with the Supreme Court. They pass orders only when they know that the person that they're passing orders on will listen. When there is a danger like these farmer rioters, they're not even protesters. They're actually slave owner protesters, because that is what the nature of the business in Punjab is. They know that they will not listen to them. These guys will sit like that Rishi who was on 24-year mantra for on one leg and living on air or water or whatever, this thing. The problem, you want to solve it right now without legislative whatever, lies with the judiciary. I don't think the judiciary realizes that it is at the center of the problem right now. And unfortunately, I agree with Justice Katju. They're just too. It's become a sort of self-reinforcing cabal of dynasts who are simply not going to break their monopoly of the cartel.
Manali wants to say something.
I must, because very strong words have been used against the judiciary, and I'm not defending the judiciary totally. Also, I do agree that there are times and incidents where the judiciary has failed the system, and they need to do a course correction over there. But please understand, one of the reasons, as I told you, was that we have a complete systematic failure, and it is so easy. And the manner in which cases are put before the court, starting from the lowest court onwards, that it makes it difficult for anyone. There is no, actually, because we don't have a free police. We don't have a free police. They are only working for their political masters and to please their political masters, whether they have either direct instructions to do something, or just because they're doing it to in some way please their political masters. The cases are put in such a manner that it is very difficult sometimes, even for a court, to straight away, if a case comes, to say, okay, grant bail to a person on the first day. Though according to me, I think a time has come where maybe for bail and all, Supreme Court should lay down guidelines, like Abhijit said. What are the conditions on which bail should be given? Those are very clear cut. The law is well settled on that. And every time even Supreme Court grants bail, they just say the same thing again. I agree with you that it should not happen, that people should not languish. But it's not, I would not say that the fault lies only with the courts. I think the fault lies with the system and the society at large. And we are now today a society which is so divided on political, communal lines, that if I say something, Shehzad feels obliged to attack me and
we need to get out of the victim syndrome now. We really need to quit the victim syndrome.
I'm not trying. I'm okay. Not Shehzad.
Stop being in the victim mode. You've lost in 2014. Stop being a victim about it.
I'm not a
Manali, can I just make a point? Manali, may I quickly make a point? Manali, will you see to me?
Get out of a victim mode. Nor am I a politician, but
Manali, just see to me for a minute. Na? Manali, can I take 2 minutes of your time? I just wanted to say, I am not suggesting monocausality. What I'm saying is, in the short term, the judiciary needs to understand that it can effect change in the short term without significant legislative changes. I'm not saying it is the only cause of the problem. I'm saying it is the biggest hurdle to immediate changes happening right now. Okay, so I'm not implying monocausality, number one. Number two, I just want to push back against this notion that in fact, I would say it is the political control of the police that is somewhat keeping the police in check. If you look at the Mumbai police and how intertwined they are with crime, I would any day trust the Mumbai police under my worst enemy than I would an independent Mumbai police under Dawood Ibrahim or whoever the latest gangster is on any given day. There is a video that's come out 3-4 days back of the local Thanedar cutting a cake and feeding the local don. ये करता है Mumbai police. Yeah. It's on Twitter. So thank you very much. I absolutely, in a third world country, in a first world country with first world judicial processes, with first world investigative processes, with first world forensics, I'm very happy to have an independent police in India over my dead body.
Don't wish for something like that.
Yeah, Justice Katju, someone.
I have to go. Sorry.
But Justice Katju, there's somebody on our chat who just wants to know if you're woke or not.
Sorry?
If you are woke, W-O-K-E.
W-O-K-E?
It's not the same as awake.
No, it's woke. Woke as in, how do you define woke with it? No. What is your definition of woke? Shehzad, you're the youngest here.
Ironically, the behavior of some people on this would be defined as woke. Being woke.
again, some people on this board, you're obsessed. The woke is, I guess, the ones, I don't know. I mean, I don't know how you define someone who's woke.
Pseudo-liberals, yeah, chhodna.
Pseudo-liberal. Is it pseudo? Okay, there are obviously positions on this subject, but yes, Justice Katju, last comments from you, and then we'll close this very.
You see, Abhijit spoke of quick decisions and all that. See, come to realities. When Article 370 was revoked on 5th August 2019, and all these Kashmiri leaders were put under detention, they filed habeas corpus petitions in the Supreme Court. Now, habeas corpus petition takes priority over everything. When I was a judge of High Court and Supreme Court, no habeas corpus petition remained pending in my court for more than 2 weeks. I would invariably give 1 week time to the government to file a reply and 3 or 4 days for a rejoinder. And in 2 weeks, this way or that way, I would decide the case. Because it's a matter of individual liberty. It has priority over everything. When a habeas corpus petition comes, all other 5 should be kept aside. This should be given the highest priority. But what was in reality done? Those Kashmiri leaders filed petitions. Cases were, after 1 month, the date was fixed, then again adjourned, again, on and on and on. Why adjourn? What impression does it give? That you are under political pressure? I mean, this is the impression which is created because you should decide it this way or that way. You will not decide it. So, in theory, what Abhijit is saying appears to be very nice. Cases should be decided quickly. But what is the reality? And then there are 45 million cases pending in the Indian judiciary. It is, you imagine that a judge is a magician. In one moment, he can decide a case. It takes time. There are so many cases. So what I mean to say is that even if you are falsely charged by the police, it will take years and years before you can get bail or acquittal. And in that time, during that time, you rot in jail. And then very often, as you know, our police manufactures evidence also. Everybody knows this. So the practical thing is very different from the theory. In theory, it may sound very nice. Oh, this should be done, that should be done. Suhel has also said, oh, institutions should be reformed, this should be done, that should be done. Keep on thinking that way, but it will not be done. The system will continue as it is. I mean, that's why I am pessimistic. Pardon me, Suhel, but I see no scope for improvement, not in any time in the near future.
You mentioned a university called Jadavpur University, and you acclaimed it. I'm from Jadavpur University, and I was born and raised in Calcutta, and I grew up at a time when the communist movement was in full sway. We had every right to be pessimistic. We had every right to be defeatist. Industry had fled Bengal. Jobs were scarce. Employment was at its lowest. But my late father only told me one thing. He says, you can always be pessimistic, you can always be negative, but where will it get you? You will continue to wallow in despair, in self-pity and hatred. That's not a place to be in, sir. आपने तो अपनी जिंदगी काट ली है ना. You're 75, you're in your twilight years. These should be your years to spread wisdom. These should be your years to spread hope. Because you've lived an illustrious career. You've been a judge of the Supreme Court of India, an institution that every Indian still respects. आपने तो अपना जीवन काट लिया बढ़िया से. अब to say कि देश बर्बाद है, parliamentary democracy is useless, you tell me, what does it make people like us feel? Now, since everyone's talking age, I'm 58. Why should I feel despair? Why should I feel defeated about the country I'm in?
Yeah.
Why should I feel apologetic about my country? Of course it has issues. So does every country. Of course we have our problems, but these are our problems. ये ISI ने थोड़ी सुप्रीम कोर्ट बनाया था. ये हमने बनाया था. हमारी कॉन्स्टिट्यूशन हमारी है. It is not a constitution belonging to Fiji or to New Zealand. If we have to change it, we have to change it. People like Shreya Singhal have to change it. The young. Shreya Singhal had no business at 21 to take on a government's might, to challenge the constitutionality of a law, but she did it. Why? Because she had hope in the country and has hope in the judiciary. You say Justice Ramana's comments are all oral, but I'm very delighted. I'm delighted by those comments. I'm delighted by comments of everyone, which are comments based and mired in hope and based on fact and substance. Because agar aap maan lijiye, we say everything is wrong, where will we go? We will be our own biggest enemy. And we have enough on our borders to attract even that. So I'd much rather be the kind of person I am, in the belief that I'm blessed to be Indian. I'm blessed to be part of this civilizational legacy. And yes, nothing is perfect. I'm not perfect. You're not perfect. But so are countries. Countries are not geographical, pyramids. They're made up of people. They're made up of aspiration, of hope, of despair as well. But it is up to us, if we are true Indians, to make sure that the last Indian standing has every opportunity made available to him or her. It's not about India being a poor country. It's the impoverishment of opportunities which is terrible. That we need to kind of ward off. That's about it.
Yeah. Thanks so much, Suhel. I think definitely, 21-year-old Shreya Singhal, taking this on. Today, there was just this decision from Rashmi Sawant, who took on the Oxford University for her illegal kind of removal as Oxford University president, and she's triumphed. So I think the next generation is really standing up for what they're believing in and ready to go to the distance. So it's something that we can all feel better about. But I think this discussion is so important because no one should end up in jail because of something they said at some point of time. There have to be bigger measures. My big takeaway from this is really accountability of people who misuse this law. I think that's essential, be it someone sitting in parliament or assembly or a politician or a minister or whoever it might be, because the common man really suffers in the end. So I really want to thank you all today. We're usually a very chatty group, so I don't know where we went off track today, but I guess that's what happens when you have lawyers on a panel. Right? There's second nature to them to argue like this. So
but I will only say this because Shehzad is younger, like a brother to me. I will say this, Shehzad. I have known Manali and her family for almost 30 years. The one thing I can tell you is she's completely apolitical and serves the best food at her home. It's a brilliantly well-cohesive, deeply patriotic family. On that note,
namaste, and thank you, everybody. And Shehzad, don't heckle people. This isn't.
No, he didn't heckle. See, now you're again.
No. Let's leave it at that. I think we need food diplomacy, and all of you should come one day to my house.
Oh, how sweet!
Including Shehzad.
How sweet!
Yes, of course. Shehzad also is. I said it on Twitter. Very rarely do I say. I said he's one of the most formidable young TV panelists.
Yes, he is.
Do you believe that?
Very
what we do is a dog and pony show, perhaps, but everyone's. See, that is what Justice Katju finally. आदमी की जो innate decency है वो आप कभी नहीं छीन सकते. तो हम हमारे politicians या जो भी है, जितनी भी hate spread करें, ultimately love triumphs. Love always triumphs. Jai Hind.
Lovely. Thank you, everyone, for joining. We had lots of comments. Thank you, Shezad, Suhel, Manali.
Thanks, Manali. Thanks, Shezad. Thank you, sir.
Thank you.
Bye, Advaita.
Bye-bye.
Also, you're notified, hit the bell.